Okay, so for this next video lecture, so we will be discussing on the non-compliance with laws and regulations. So we have already finished about the misstatements or material misstatements due to fraud or errors in the previous video lecture under this module. So this is the second part, okay, of module 8. So here we have in PSA 250, so this is entitled Consideration of Laws and Regulations in an Audit of FS. So this deals with the auditor's responsibility to consider laws and regulations when performing an audit of FS, because if the entity do not comply or follow the requirements of the law, so meaning this would also result into misstatement, especially if that laws and regulations relate also to the accounts or transactions which is reflected in the FS. Okay, so it has the material effect probably, okay, on the presentation of their FS. So therefore, the auditor should consider non-compliance of the entity. So non-compliance, this is the acts or of omission or commission, meaning there is a law or regulation but the entity did not follow it, or there is prohibition to do something but the entity did it. Okay, so meaning they did not comply with what is written in the rules and regulations under these laws. So these are intentional. This may be intentional or unintentional. But when it comes to laws and regulations, we have this quote that although you are, or ignorance of the law does not excuse anyone. So meaning if you are not aware that there is a law for that and you committed such, still you are liable. Okay, so that's why non-compliance may be unintentional also. Okay, so this is committed by the entity or by those charged with governance, by the management, or the other individuals working for or under the direction of the entity, which are contrary to the prevailing laws or regulations. So non-compliance do not include personal misconduct, okay, unrelated to the business activities. Non-compliance here is related to the entity as a whole and not on the individual person. Okay, for example, if the employee or the management committed a crime that is not related to the entity, then that will not be included under non-compliance. It's their personal liability. Okay. So there are two types of non-compliance with laws and regulations. So the first one is non-compliance with provisions of those laws and regulations generally recognized to have a direct effect on the determination of material amounts and disclosures in the FS. For example, violation in tax laws and pension laws. Okay, so this is the first one. The second one is non-compliance with other laws and regulations that do not have a direct effect, meaning the effect is indirect, okay, on the determination of the misstatement in the FS, but on the operating aspects of the business to an entity's ability to continue its business or to avoid material penalties, so such as compliance with the terms of an operating license or occupational safety. So the first one is non-compliance with the laws which have a direct effect on the FS. The other one is non-compliance with laws and regulations which has indirect effect. In this case, it does not directly affect the FS, but it will affect the operations or the ability to continue the business. Okay, so in this case, if there is non-compliance with such laws, then the entity might be closed. So meaning their presentation of their FS should not be based on a continuing business or what we call um, the ability of the entity, okay, to continue. And in such, they should prepare their FS as if they will be closed. So different measurement, okay, will be uh, presented in the FS. Okay, so that's why in this case, although this non-compliance is indirect, but it will have later on the effect on its presentation as well. Okay, so this is the two types of non-compliance with laws and regulations. Okay, so examples of laws and regulations that may be included in the categories that are described includes those that deal with, okay, if there is fraud, of course, that is a violations against the law, okay, corruption and bribery, money laundering. So money laundering is the source of the money is illegal, but they make it appear that this comes from a legal source. So for example, there was a kidnapping and the ransom money was given to the to those who have committed the kidnapping. So what they will do is to deposit it in the bank, and then they will make it appear that they have a business, okay, that where that cash comes from, when in fact it comes from committing a violation of the law. Okay, so that is what we mean by money laundering, meaning dirty money, they laundry it to make it clean, to make it appear that it comes from a clean source when in fact it's not. Okay, so money laundering. Another is security markets and trading. So this relates to the misappropriation of assets, where these assets can easily be converted into cash, and even without the need for authorization or documents, okay, for selling or buying it. Another is banking and other financial products and services. Okay, so in this case, most of the time, since it deals with, or for example, with the misappropriation of assets, so they may engage into banking and other financial products and services to conceal such fraudulent activities or actions. Okay, data protection also, because in this case, data and information are very sensitive, and it should be considered to be personal and should not be shared with other entities. Okay, so violation of this act or this also will result into non-compliance, because we have the Data Privacy Act, okay, to protect the data or personal information of a certain person or entity. Okay, another is tax and pension liabilities in payments. Okay, so this, if the entity will violate such, then it has the direct effect on the FS, okay, as mentioned in the types of non-compliance. Another is environmental protection, okay, public health and safety. Okay, those are the different examples of laws and regulations that may be included. Okay, that where the entity is required to comply with. Okay, so we will continue with the management and auditor's responsibility in non-compliance with laws and regulations. So here, what is the management's responsibility in non-compliance with laws and regulations? So basically, it is their responsibility, together with those charged with governance, to ensure that the entity's operations are conducted in compliance with applicable laws and regulations, or else they will be punished and charged with penalties. Okay, So it includes those laws and regulations that determine the reported amounts and disclosures in their FS as well. So in preventing and detecting non-compliance, an entity may implement the following policies as part of their control to make sure that they comply with these laws and regulations. First is they can monitor legal requirements and ensure that operating procedures are designed to meet these requirements. So they can set up a department to do such, or even the internal auditors to do it for them. Okay. Another is the instituting and operating appropriate system of internal control. So this will cover everything. Okay. Another is ensuring employees and properly trained and understand the code of conduct so that they will be able to follow as well and comply with rules and regulations. Another is ensuring employees are properly trained the same. Okay, another is monitoring compliance with the code of conduct and acting appropriately to discipline those who fail to comply with it. Okay, another is engaging legal advisors to assist them in monitoring their legal requirements, especially in the interpretation of the laws and their responsibilities for complying with such. Another is maintaining a register of significant laws and regulations with which the entity has to comply within its particular industry and a record of complaints. Okay, so again here, they will need the help of a legal advisor. So if feasible, assigning appropriate responsibilities to an internal audit function or an audit committee and a compliance function to help them monitor, implement, and assess whether they comply with those rules and regulations. So those are the different responsibilities of the management with non-compliance. What about the auditor's responsibilities in detecting non-compliance? Okay, so the auditor, he is responsible for obtaining reasonable assurance that the FS, taken as a whole, are free from material misstatement due to fraud or error. Okay, so we've mentioned that in our in the first part of this module. So when performing an audit, the auditor should also recognize that there may be some non-compliance that the entity may have committed, which will result into material misstatement on their FS. So the auditor should also consider non-compliance because it may result into material misstatement in the FS, not only fraud or error. Actually, non-compliance can also be part of fraud or error. Okay, but in this case, this is specific because there are rules and regulations that they need to comply with. Okay. Another is, unfortunately, an audit cannot be expected to detect non-compliance with all laws. The auditor is only concerned with non-compliance that has the effect of misstating the FS. Okay, and again, it is not the responsibility of the auditor to detect all or non-compliance. Okay, for those non-compliance that have a direct effect on the FS, the auditor's responsibility is to obtain sufficient appropriate audit evidence regarding this compliance, okay, to support his opinion or to determine whether the entity has complied or did not comply with such laws and regulations. For those non-compliance that do not have the direct effect on the FS, so the auditor's responsibility is limited to undertaking specified audit procedures to help identify non-compliance that have only a material effect on the FS and not on all those laws and regulations which were not complied with by the entity. Okay, so detection of non-compliance requires consideration of the implication for the integrity of management or the employees and the possible effect on other aspects also of the audit. So here the auditor will contemplate on its effect on the FS and should consider its materiality. So whether an act constitutes non-compliance is a legal determination that is ordinarily, this is beyond the auditor's professional competence. So in this case, he can ask for the help of an expert or legal advisor, okay, to assist him in determining and gathering the appropriate sufficient audit evidences. So the auditor's training, experience, and understanding of the entity in this industry may provide the basis for recognizing some acts coming to the auditor's attention that may constitute non-compliance of the entity. So nevertheless, the determination as to where the particular act constitutes non-compliance is ultimately a matter that will be determined by the court or other appropriate adjudicative body. Okay, but somehow if there are rules and regulations which the entity has performed with a deviation from such, so it may constitute also non-compliance. But again, the auditor cannot judge it absolutely that they did not comply unless the court of law or other appropriate body have determined it. Okay, but it can indicate also of non-compliance. So the auditor is not responsible for preventing non-compliance and cannot be expected to detect non-compliance with all laws. So here it is the responsibility of the management and those charged with governance. So the fact that an annual audit is carried out, this may also act as a deterrent, meaning it will help the entity to detect or to call their attention of the existence of non-compliance or if they did not comply with laws and regulations. But in the first place, this is the primary also responsibility of the management. Okay, so those are the responsibilities of the auditor for the non-compliance of the entity. Okay, and then the auditor should plan also and perform the audit with professional skepticism and recognize that the audit may reveal conditions or events that would lead to questioning whether the entity is complying or not with those laws and regulations.